Do you want to know about corporate insolvency resolution process? Stay tuned till the end. Before even proceeding to the video, do not forget to subscribe to our channel, tap the bell icon to receive our latest notifications. Corporate insolvency resolution process is the first important activity which is going to happen under Insolvency and Bankruptcy Code. As we have already discussed couple of times, the primary objective of the Insolvency and Bankruptcy Code of 2016 is not to declare a person bankrupt, is to ensure that he recovers from that particular position so that the insolvency state should not continue. Everyone opportunity should be given to revolve from the situation of insolvency so that they will no more be considered as insolvents and then they will be able to continue their business in a normal way. That is the basic objective of the Insolvency and Bankruptcy Code of 2016. Please note, corporate insolvency resolution process is the first step. If the company has defaulted in making repayment of the loans, then the persons who are aggrieved can move a petition before the National Company Law Tribunal under corporate insolvency resolution process. The first important question which is required to be answered is, who is eligible to make an application? Please note, an operational creditor can apply, a financial creditor can apply, and corporate debtor himself can make an application for corporate insolvency resolution process. Who is an operational debtor? Who owns an operational debtor? That means, he would have raised an invoice to the company has not repaid the invoice money. Secondly, like financial creditor means the company would have taken the loan and the company has not repaid the EMI. The third one is company itself. Understanding the situation that the company is not able to repay the debts, it can offer itself a resolution plan. So these are the people who are eligible to make an application. Please note one more point that you have to keep in mind. The debt should be more than 1 lakh. Then only a person can make an application. In addition to that, if the company is already undergoing a corporate insolvency resolution process, simultaneously one more cannot start. And if a CIRP process is already completed, there is a minimum waiting period of 12 months which is required to be complied with. Then only they can apply for a fresh corporate insolvency resolution process. This is step number 1. Step number 2 will be appointment of a resolution professional. Please note, an insolvency professional can be appointed as a resolution professional, and then the third step will be filing a petition before the National Company Law Tribunal for CIRP. Once the petition is accepted, the next important stage is the National Company Law Tribunal will order a period of moratorium. Moratorium is a legal terminology which will be available for a period of 180 days. That is the maximum time within which the entire process of corporate insolvency resolution process has to be completed. Of course, there are extensions available, but still on the primary note, we need to understand that 180 days is the period which is available for completion of the process of corporate insolvency resolution process. What is going to happen during the period of moratorium? Please note, this is moratorium means it is like freezing the fresh claims which has to come to the company. Take for example, the company is facing lot of legal proceedings, that will be stopped for a period of 6 months, that is 180 days. Please note, it will be temporarily stopped. It is not like totally all the petitions will be cancelled. After 6 months or the completion of the CRP process, everything will continue. The objective is, in this moratorium period, they should completely concentrate on the corporate insolvency resolution process. That is the basic objective. Now at the last stage, what needs to be done is, a resolution plan will be prepared by the insolvency professional. That means he is a resolution professional. He has to get it approved from the members, he has to get it approved from the creditors, and then he has to ensure that the resolution plan is being approved by the National Company Law Tribunal also. Once the resolution plan is approved by the National Company Law Tribunal, according to the resolution plan, all the payments are required to be made. This is the success story of a corporate insolvency resolution process. If the resolution professional is not in a position to come out with a resolution plan, automatically the corporate insolvency resolution process will end up in liquidation process. This is the consequence of non-completion of corporate insolvency resolution process. If you have any questions, please comment. If you want to learn more about this subject, corporate restructuring and insolvency, please fill the Google form which is being given in the description box below. You can even join our Telegram channel and you can visit our Ekcel Academy website for the latest notifications. If you liked this video, do not forget to tap the like button and share it to your friends. Do let us know if you need anything else. We will be very happy to get back to you.